Our next speaker is Miss Padmaja Wijesooriya. She holds an LLB degree from the University of Lanka and postgraduate master's degree LLM from the same university. She is also an attorney at law and a lecturer in law at the General Sir John Defence University, and her research interests include environmental law and intellectual property law. She will enlighten us on biodiversity and bio-piracy with special reference to Sri Lanka.
Distinguished guest, Chair, and students, and good afternoon to you all. Today, my research is based on biodiversity and biopiracy with special reference to Sri Lanka. I selected this area because the biopiracy is a very controversial issue in present days. So, my outline of my presentation is as follows. It is research question, research objective, research methodology, what is biodiversity and what is biopiracy, features which are considered for granting patent license, and the next question is a plant, a patentable subject matter, and relevant laws on Sri Lankan legal regime as well as international legal regime, and conclusion and recommendation. So, moving to my next slide, the research question. So, my research question is Sri Lanka has an adequate legal framework to prevent biopiracy over the biological resources in the country itself? My research objective of this study is to identify a sui generis legal framework to protect plant resources of Sri Lanka. Research methodology of this study is based on a literature survey in the area of law relating to intellectual property at both domestic and international level. So the main question, I like to draw your attention for the definition of biodiversity. I took this definition from the Convention of Biological Diversity, Article 2. According to the Article 2, biodiversity is the variability among living organisms from all sources including interior, terrestrial, marine and other aquatic ecosystems and the ecological complexes of which they are part. This includes diversity within species, between species and of ecosystems. And moving to next slide, it defines what is biopiracy. Biopiracy is the commercial use of plants and traditional knowledge of the use of plants without compensation, acknowledgement and the informed consent of the owner. So the biopiracy is use of plants without compensation, acknowledgement and the informed consent of the owners. Before I discuss the domestic and international legal framework, I would like to draw your attention about the features which are considered for granting patent. There are three major features, that is novelty, inventive step and usefulness. Novelty is something new. So an invention has to be new or at least a significant new improvement to an existing invention. Since it is not possible to define what is new or novel, it is defined as part of prior art. The term prior art defines differently in countries, but in general it is meant to cover existing knowledge. And the inventive step is a step in the making of new invention, and it is not obvious to a person skilled in the particular area of science or technology. It is deemed to be an inventive step. So, the usefulness is the invention should have a use or an application. This is in many countries has to be real use, but in some even a potential use is considered to be adequate. So, the question is a plant a patentable subject matter? The Intellectual Property Act number 36 of 2003 provided that plants, animals and other microorganisms other than transgenic microorganisms and an essential biological process for the production of plants and animals other than non-biological and microbiological process could not be patentable because the features of the patent, that is novel inventive steps and usefulness, the three major factors are not with these plants because it is already existing in the environment. So, but when we discussing a plant as patenting, so we can't patenting, but we can improve or implement a sui generis legal framework to protect this plant from pirating it. So the lawmakers of Sri Lanka have taken some steps to protect plants in the country by drafting some legal documents like Draft Bill for Protection of New Plant Varieties 2001 and 2014 and Draft Bill for Access to Traditional Knowledge relating to use of medicinal plants 2000. The question is, these significant instruments are still in drafting level. Anyway, in Section 2 of Draft Bill for Plant Variety Protection provided that in order to obtain the intellectual property rights for the breeders should present the features of novelty, distinctness, uniformity and stability of the new plant variety. And moreover, according to the Section 8 of the Draft Bill for Protection of New Plant Variety, it is provided provisions for entitlement to protection. That is, as per the section, it is provided that the breeder of the variety of his successor is entitled to apply for the protection under this draft bill. And moving to the Draft Bill for Access to Traditional Knowledge relating to use of medicinal plants, this is drafted by National Intellectual Property Office in Sri Lanka in the purpose of preservation of traditional knowledge associated with medicinal plants by preventing biopiracy and safeguarding the interest of the holders of such traditional knowledge. And when we considering about the international legal regime, there are two significant instruments. One is Agreement on Trade-related Aspects of Intellectual Property Law, and the other one is the Convention of Biological Diversity. There are more, but my study is basically based on these two instruments. According to the TRIPS Agreement, Article 27 mentioned that plants and animals other than microorganisms and essentially biological process for the production of plants or animals other than non-biological and microbiological process would not patentable subject matter. But in its proviso mentioned that the member states shall provide for the protection of plant varieties either by patent or by an effective sui generis system or by any combination thereof. Therefore, these provisions can be considered as kind of protection granted to against biopiracy in the world. Therefore, some developed countries vehemently oppose adhere with these provisions provided by the TRIPS Agreement. And moving to the Convention of Biological Diversity, Article 8, Sub-Article J of Convention of Biological Diversity enacts the enhancement of traditional knowledge among the biodiversity of the state. Article 8, Sub-Article J provided that, subject to its national legislation, respect, preserve and maintain knowledge, innovation and practices of indigenous and local communities, embodying traditional lifestyle relevant for the conservation and sustainable use of biological diversity and promote their wider application with the approval and involvement of the holders of such knowledge, innovation and practices and encourage the equitable sharing of the benefits arising from the utilization of such knowledge, innovation and practices. That is, HA guided to share benefits arising from the utilization of such knowledge, innovation and practices. But the problem is, in Sri Lanka, my recommendation, we have drafted this, but it is not in the implementation level. Therefore, my recommendations are implement the sui generis legal framework such as laws relating to plant variety protection and laws relating to access to traditional knowledge can we protect the plants within our country. And further, as we know, the system of intellectual property law is dominated by developed states and their multinational corporations, both of which operate from neoliberal tradition. Therefore, for the sake of protecting plants inside the developing countries, the globalization of Western intellectual property regime must be opposed. Thank you.